Navigating restraints and seclusion, empowering families to advocate effectively. What is a restraint? It's any method or device used to involuntarily limit one's freedom of movement. This can include, but is not limited to, physical restraint, mechanical devices, chemicals, and seclusion. Exceptions that are not considered restraints include the 1-minute rule for a physical restraint, which means that a restraint less than a minute does not meet the definition of a restraint. The holding by one adult for comforting or calming a student is not a restraint. Prescription medication and mechanical devices in accordance with a student's individualized education program. When are restraints allowed in Colorado public schools? They are allowed in emergency situations only, and options include physical restraint and seclusion, and they are only to be used after the failure of less restrictive alternatives or if it's determined that those alternatives would be ineffective. They are not allowed as a chemical restraint or a mechanical restraint or prone position, a face down restraint. Restraints should never be used as a punitive form of discipline or as a threat. Prone position or mechanical restraints are allowed if conducted by an armed security officer with appropriate training who has notified law enforcement, or when a student is openly displaying a deadly weapon. What constitutes an emergency? An emergency is serious, probable, and imminent threat of bodily harm to self or others, with the present ability to cause such injury. This includes situations in which a student creates such a threat by abusing or destroying property. Bodily injury includes physical pain, illness, or any impairment of physical or mental condition as defined by Colorado Revised Statutes Section 18-1-9013C. What is a chemical restraint? This involves administering medication, including those prescribed by the student's physician, to a student on an as-needed basis for the sole purpose of involuntarily limiting the student's freedom of movement. This is not allowed. It does not include prescription medication that is regularly administered to the student for medical reasons, such as ADHD medication. The administration of medicine for life-saving purposes, such as an EpiPen, would also not be considered a chemical restraint. What is a mechanical restraint? This is a physical device used to involuntarily restrict freedom of movement. It is not allowed in Colorado. It does not include devices recommended by a physician, occupational therapist, or physical therapist, and agreed to by the IEP team. It also doesn't include protective devices that's in accordance with a student's IEP, or adaptive devices recommended by a therapist and consistent with the IEP, or positioning or securing devices that are used to treat medical needs. What is a physical restraint? This is the use of bodily force to involuntarily restrict one's freedom of movement. It does not include holding of a student for less than 1 minute, or the brief holding of a student for calming or comforting, or minimal physical contact for safely escorting a student or helping with a task. In a physical restraint, the staff must release the student when the emergency is over. What is seclusion? This entails placing a student alone in a room in which they are not permitted to leave. The room must have adequate lighting, ventilation, and space, and to the extent possible, It must be free from hazardous items. Staff must have the ability to monitor the student while in a seclusion. Seclusion is a form of restraint. If you are unsatisfied with how or why your student was restrained, there are complaint process options. You can meet with your IEP team. You can request an internal investigation from the school district. You can file a complaint with the Colorado Department of Education or with Disability Law Colorado or the United States Department of Education Office for Civil Rights. You can report the restraint to the police. You can contact media, or you can file a civil lawsuit. The Colorado Department of Education's process includes accepting or rejecting your complaint within 10 days of filing. The district will then have 15 days to respond, and the parent will have 10 days to reply to that response. The completed investigation and decision happens within 60 days. It is the same as the IDEA grievance process, and a third party can file on behalf of a parent. Learn more at advocacydenver.org. Thank you.